Moving on then to our next topic within English legal system, the topic called sources of law. And we're looking at who makes the law, where does the law come from. This is quite a big topic. In your notes it goes on for pages. It's also very, very popular with your examiner. And because it is a big topic, I just want to start off first of all very quickly identifying the sources of law so we know what we're going to be talking about. And there are three sources of law for England and Wales. And by the way, this is sources of law for both civil and criminal law. There's no difference here. So three sources of law for England and Wales. There's case law. Do you remember we said that's by the judges? There's also legislation. Remember that's Parliament. And then there's also European Community law, sometimes called European Union law. Apart from knowing of its existence, though, further consideration of European Union law, European Community law, not within our syllabus. So we're now forgetting about that. So we need to look at case law, we need to look at legislation. And I want to start off looking at case law, common law and equity. So let's imagine there's an exam question asking you about case law. The first thing you need to do is to tell the examiner generally what it is. So very simply, you tell him that it's law developed by the judges as they're deciding cases in the courts. It's also got another name that you could add in. Case law is also called, also known as, judicial precedent. Judicial to do with a judge, precedent, something that happened earlier, an earlier decision of a judge in a case. We divide case law into two types. There's common law and there's also equity. Now, what you're examined on in your exam is the similarities and differences that there are between common law and equity as they exist today. You're not examined on the different historical development. The only thing is, though, you can't actually understand the current day position unless you know the historical development, because all the differences and similarities today have their roots in history. So your notes deal with the current day position. I'm now going to tell you the history so that you can understand the modern day position. Well, for this history, we have to go back to 1066. You might know, major event in English history, the Battle of Hastings. It's where William the Conqueror, also called William of Normandy. Normandy is now part of France, but in those days it was a separate country. Well, William of Normandy, he came over to near Dover. He had this battle, the Battle of Hastings, where he shot the existing king in the eye with an arrow and thereby conquered what we now know as England. Actually, in those days, it was not a unified country. In fact, it was split up into little local areas, each area being called a manor, and each being ruled over by a lord of the manor. Well, when William the Conqueror came, what law did he find? Well, there wasn't really any. It was a pretty lawless place. If there was a dispute between people from different manors, then they fought about it, they had a battle. If there was a dispute between people within the same manor, then the lord decided he's the lord. Well, when William the Conqueror came, there were two things he wanted. First of all, he wanted a strong, centralised system of government. These little mini kings around the place, too difficult to rule. So he set himself up in Westminster. Westminster was the centre of power. London didn't really exist in the same way it exists today. But his second and much more pressing need was money from his new subjects, in other words, tax. So he sent out from Westminster travelling tax collectors. Now, at least initially, he had to use the existing systems, and in fact the tax was due from each and every manor, not from individuals like it is today. So one of the king's travelling tax collectors would arrive at the manor, knock on the door or the gate or whatever it is, and demand the tax that was due. Quite obviously, there are often disputes, and these tax collectors got really quite good, got skilled at deciding disputes. In fact, so skilled that gradually, and by the way, when I'm saying gradually in this history, 100 years or more might well be passing. And so gradually the local people began to recognise these skills and would ask the tax collectors to decide not just tax disputes, but all disputes. And so gradually, actually, they ceased to collect tax altogether and turned into travelling judges. Well, right at the beginning, what was the law that they were using to decide the disputes? Well, as we said, there wasn't any really. What there was, though, was local customs. Customs local to each and every manor. So if one of these travelling judges was deciding a dispute in a particular manner, the first thing he would have to do is to do some research to find out what the relevant local custom was, so that he would then use that custom to decide the dispute. And let's imagine that the next week he's at the next door manor and much the same dispute arises. He's got to do more research to find out what the custom is at that particular manor. Well, when the travelling judges gathered back in Westminster, which they did, they would discuss the various customs that they came across. And between themselves, they agreed what they thought was the best of the local customs, such that when they went out on their judging travels, they applied the best customs to the entire country. In other words, the best of the local customs became common to the entire country and came to be called this body of law we call the common law. So that actually then gives us our first major characteristic of the common law. In developing from local customs, which became common to the entire country, it developed as a complete system of law. So it is a fundamental, basic system. Because of the way it developed, it's also sometimes, at least colloquially, called the people's law. In that it has its roots in the customs of the people. It grew up from the bottom. Nobody ever stood on high and imposed the common law downwards. It has its roots in the customs of the people. Another characteristic of common law, again due to its historical nature, it's what we describe as unwritten law. In that nobody, even today, has sat down and written out all the rules of common law. It's developed through the cases, through the decisions of the judges. Well, that's common law. We now need to factor in equity into all of this. Even though common law developed as a complete system, in fact, there were gaps in it. It was actually quite narrow, quite restrictive. It didn't give people everything they wanted. For example, the only remedy recognised by the common law was that monetary one of damages. Those two others we mentioned earlier, specific performance and injunction, were simply not available at common law. So people began to get a bit dissatisfied with the common law. Well, if you were one of those dissatisfied people, there was something you could do. You could petition the king directly. If you had enough money, of course, that is. And of course the king could recognise your right, grant you a remedy. He's the king, he's all-powerful. Well, people began to regard these petitions as a good thing, so much so that they multiplied, and the king could not deal with them all personally. So in fact he was forced to hand them on to his right-hand man, called the Lord Chancellor. Just updating, the office of Lord Chancellor still exists today. Today he's a political figure with a seat in Cabinet. He's the head of the entire English legal system today. Going back to the Lord Chancellor in those days, the King's right-hand man. He was an ecclesiastic, a churchman. So he would recognise your right, grant your remedy in the name of the King, on the basis of what he thought was fair, or on the basis of what he thought was just, or to use another word, on the basis of what he thought was equitable. And it's the decisions of the Lord Chancellor in the name of the King that grew up to be this body of law which we now call equity. So that gives us then our first characteristic of equity. In developing piecemeal to fill in the gaps in the common law, it's an incomplete system. We're doing theory at the moment, but as we get particularly into contract at a later stage, you'll find we'll do a whole load of common law rules, and then every now and then we'll stop and say, but there's a little bit of equity coming in on the top here. You'll see the idea of the bits and pieces nature of equity. It's sometimes described as a gloss on the common law. Because of the way it developed, it's also at least sometimes called, very colloquially, the King's Law. Because it developed in the name of the King. It does actually share a characteristic with common law, the same characteristic, in that, like common law, equity is also unwritten. So nobody, again, has ever sat down and written out all the rules of equity. It was just developed by the Lord Chancellor and his judges in the courts. So that's our first characteristic of common law and equity. Moving on to the second characteristic, firstly, of common law. Common law rights and remedies are available as of right. You have an entitlement to things common law. So let's imagine that you're suing for breach of contract. You allege and prove that there is a breach of contract, and you ask for the remedy of damages, which is a common law remedy. The judge must award damages. He can't up and say, don't feel like it today. You have a right, an entitlement. Things are very different with equity. Equitable, so-called rights and remedies are given at the discretion of the court. This is history. Equity was within the gift of the king. You could not demand things of the king. And this is still the position today. If you ask for an equitable remedy, say specific performance, which is equitable, the judge can up and say, don't feel like it today. Well, actually these days, the discretion is exercised according to well-known guidelines, well-known principles. We will be finding a lot of them when we do the law of contract. And just to give you a flavour of two of them at the moment. The first one, a maxim or saying. Delay defeats the equities. So if you want an equitable remedy, you must go along to the court quickly. There is no set period. It's whatever is a reasonable time. And to give you an idea of a rule of thumb, how long we're talking about, by way of comparison. For the common law remedy of damages for breach of contract, it's a set period of 6 years that you have in which to sue. Equity is nothing like that. Equity is in terms of days, weeks and months, nothing like 6 years. So it can be a very much shorter time. The second maxim of equity. He who comes to equity must come with clean hands. So if you've been engaging in dodgy or unfair conduct, you will not get an equitable remedy. We often express this second one a different way. We say, he who wishes for equity must do equity. So that's a second characteristic. Common law available as of right, all equitable things within the discretion of the court. A third matter. If there is a conflict between equity and common law, then equity prevails. This is back to history again. The king's law prevails over the people's law. And finally, at point 4, a similarity. And that is that both were and are being developed according to the doctrine of judicial precedent. So they're both a product of the doctrine of judicial precedent. Now, when you're doing questions on case law in the exam, you must cover the doctrine of judicial precedent. At least half of your answer, if not more, should be on the doctrine of judicial precedent because it's so important. However, it's also a standalone topic within the English legal system. It can have a question in its own right. So we're delaying doing the doctrine of judicial precedent to a later stage. So let's move on to our second type of law to develop, legislation. As we said earlier, this is to do with Parliament. And of course, if your examiner is asking you a question about legislation, you need a nice clear sentence to describe it. And we can actually say that this is law made either by or on behalf of Parliament. Then you ought to identify the examiner that there are two subtypes. There is the Act of Parliament, also called statute, and there's delegated legislation. The Act of Parliament or statute, that's the type which is made by Parliament. That's the type which is made by Parliament itself. But these days, Parliament doesn't have the time, nor indeed the expertise, to make all the law needed by a modern society. So it's forced to delegate the job of making law to others. Hence, delegated legislation, which is made on behalf of Parliament. Looking then at each in turn, the Act of Parliament, which, as we said, is made by Parliament itself. Now, a little bit of general knowledge here. Parliament. What do we mean by Parliament? And I'm just filling in background general knowledge so we're all up at the same level. Well, Parliament actually consists of 3 institutions. There's the House of Commons, there's the House of Lords, and there's also the Queen in Parliament. The House of Commons consists of MPs, members of Parliament. It is an elected body. The House of Lords, currently it's mostly appointed. There's quite a lot going on at the moment regarding reform of the House of Lords. And then the Queen, that's her in her official capacity as head of state. So if something's going to become an Act of Parliament, it's got to be approved by the Commons, the Lords and the Queen. As your notes tell you, an Act starts life as a bill. The bill is the name for the draft Act of Parliament. And most bills are introduced into Parliament by the government of the day. That's the party in power, the party that won the last election. They want to propose the law. Well, in order for the bill to become an Act of Parliament, it must go through 5 stages. I'm just going to quickly describe them to you. There's the first reading. That's really a formality. The title of the bill is read to the House. Then there's the second reading. That's a debate on the general principles of the bill. Then there's what's called the committee stage. The bill is sent into committee to be considered in detail by a small number of MPs or Lords, as the case may be. Then stage number 4, that's the report stage. That's where the committee report back to the House of the outcome of its deliberations. And it's at that 4th stage, the report stage, where the House will be voting on the bill line by line, clause by clause. Then stage 5 is for the third reading. Conventionally, that should just be for last-minute grammatical amendments. 5 stages. Well, actually, no, not 5 stages. 10 stages. Because it's got to go through those 5 stages in both the Commons and in the Lords. And it's only after it's done all of that does the bill go to the Queen for her royal assent. And what I just want you to realise here that this is not a speedy process of making law. It's slow, it's inefficient, but it is democratic, of course. Once a bill receives the royal assent, it then turns into an Act of Parliament. For example, an Act you will become extremely familiar with, the Companies Act 2006. 2006, that's the date the Act received the royal assent. It turned in from a bill into an Act of Parliament. But very few Acts of Parliament become operative law at the date of royal assent, particularly if an Act of Parliament is going to make major changes, then you need to give people time to get used to it, to alter their systems. And in fact, a lot of the Companies Act 2006 didn't start coming into effect until 2007 and 2008. So be careful, if you read an Act of Parliament, don't assume that it's effective law. It may not yet be in operation. Now, before we go on to look at delegated legislation, there's something that we've got to look at that underpins the whole of legislation. We've got to look at the doctrine of sovereignty of Parliament. This is an idea, a concept, a principle. And we need to do it because it's something which impacts on the whole of your studies. So, what does this doctrine say? Well, it says Parliament is sovereign. In other words, Parliament has supreme lawmaking authority. So, what does that actually mean, though? Well, we can identify 3 things it means. In theory, at least, Parliament can make any law it sees fit. There are no limits, then, on Parliament's power to make law. How come? Well, unlike most countries in the world, we here do not have a written constitution. Most countries have a constitution which limits the power of their parliament to make law. We don't have a written constitution, so it follows there are no limits on Parliament's power to make law. And this therefore means that the judges must apply Parliament-made law. They cannot declare it void as being unconstitutional. So that's the first thing we mean when we say Parliament is sovereign. Let's get on to the second thing. In theory, at least, it is only Parliament that can make new law. It is not, then, for the judges to make new law. Well, how come case law? Didn't we say they made case law? Well, actually we didn't. We said that case law is law developed by the judges. The idea then is the law is always there in the local customs, it was just developed by the judges. But really, the judges are making law, because when they're developing existing when they're developing, extending existing law to a new situation, they're in effect making new law. But they only make new law by this creeping extension. What judges certainly cannot do is do a quantum leap and make an entirely new law where none existed before. That is solely the prerogative of Parliament. On then to the third thing this doctrine says. And it says, each Parliament is sovereign. All that means then is a later Parliament can always repeal a law made by an earlier Parliament. So nothing is ever written in stone. Just before we move on, I said a later Parliament can always repeal a law made by an earlier Parliament. Well, if we've got an Act of Parliament, how do we repeal it? How do we get rid of it? What do you think? Those of you who are thinking you need another Act of Parliament to get rid of the existing one, you're exactly right. So notice it's not only slow and time-consuming to make an Act of Parliament, it's similarly slow and time-consuming to unmake, to repeal an Act of Parliament. Well, that's our first form of legislation, the Act of Parliament. Now, let's now move on to the second form, delegated legislation. As we said earlier, these days Parliament doesn't have the time, nor indeed the expertise to make all the law needed by a modern society, so it's forced to delegate lawmaking powers to others. And we said earlier, delegated legislation, it's legislation made not by Parliament itself, but made on behalf of Parliament. Now, theoretically, Parliament could delegate lawmaking powers to any person or body it sees fit, even to you. Well, it could do. But we need, for the purposes of your exam, to look at three situations where Parliament commonly delegates lawmaking powers. So we're going to look and see the types of delegated legislation, to whom the power is delegated, and for what purpose. Statutory instruments, commonly made by government ministers, under powers delegated to them by an Act of Parliament. The Act, which gives them the power, is called an enabling Act, because it enables them to make delegated legislation. Now, statutory instruments are very, very important for business. To give you an idea of how important in terms of volume, in last parliamentary session, just over 40 Acts of Parliament were made. In the corresponding period, nearly 8,000 statutory instruments were made, often affecting business. So very important in terms of volume. So let's add in some purposes, some uses of statutory instruments. What are they commonly used for? Firstly, to add detail, often highly technical detail, to a framework Act of Parliament. For example, the Health and Safety at Work Act of 1974 says that an employer must have a reasonably safe and healthy workplace. But that very same Act of Parliament authorises the relevant minister to put in place detailed safety regulations by statutory instrument. And he's done so, specifying not only things like how many first aid boxes you've got to have, but exactly how many bandages you've got to have in it, the length, the width, and even the material of the bandages. Not the kind of detail that MPs actually wish to waste time discussing in Parliament. Much better to leave those technical matters to those on the ground. A second use of statutory instruments is to alter monetary and other limits. For example, in relation to social security benefits, the amounts would need to be upgraded each year, at least in line with inflation. It would be a nonsense to have a full-scale Act of Parliament just changing a few figures. So the practice is there to be an Act of Parliament setting the base figure, and then that same Act of Parliament to enable the minister to alter the amounts as and when, within limits, of course, set out in the Enabling Act. So that's to alter monetary and other limits. A third one is to make commencement orders. And this harks back to what we were talking about earlier. Remember we said, rarely these days does an Act of Parliament come into operation at the date of royal assent. It comes into operation, it commences, usually on dates specified by the relevant minister in a statutory instrument called a commencement order. So that's the statutory instrument, very, very important for business. On to the second type, the by-law, made by local authorities. So they are local laws. They're targeted to deal with local issues with which central government is not concerned. On to the third one, orders in council. Technically, these are made by the Privy Council in the name of the Queen on the advice of the Prime Minister. So, who really makes them? Well, it's the Prime Minister, isn't it? He says, do it, and they do it. Incredibly undemocratic. Now, they could be used for anything at all, but in practice, they tend to be kept for emergency measures. Like if there's a war or a sudden disaster, we might quickly need new law. Wouldn't be efficient for Parliament to do that. And some of you will also know Parliament has very, very long summer holidays. It would be a problem if the disaster arose in the summer holidays. Now, a very common question is for your examiner in Part A to say, explain what you understand by delegated legislation. That's what we've just been doing. Part B will then say, explain the advantages and disadvantages of making law in this way. And if you're just quickly looking at it, we've actually already discussed them on the way through. But the one that I want to think about a little bit more is the very last one. That's the last disadvantage. Number 3, there's a possibility of loss of control over the lawmaking process. Because if you're delegating to a minister or whatever, there's at least a danger that he might exceed his delegated powers. So, what controls are there then on delegated legislation? Well, first of all, there is parliamentary control, in the sense that the Act of Parliament, the Enabling Act, will set out the limits of the delegated power. So it will say to increase social security benefits on the 1st of March each year in line with inflation plus or minus 2% or whatever it is. So that of itself is a control. There's also a joint scrutiny committee, joint of both houses, whose job it is to scrutinise draft statutory instruments, and if there's something wrong with them, they will return them to the minister, who presumably then remakes them. There's also the laying procedures, in that some statutory instruments, but not all, have to be laid before Parliament. This gives the MPs an opportunity to object to them if they so wish. More important perhaps than parliamentary control is judicial control. The judges, the courts. It's called judicial review. The judges have the power to review the validity of delegated legislation. And if they find that the minister exceeded his powers, acted beyond the limits set out in the Enabling Act, then the judges can declare that statutory instrument to be ultra vires and therefore void and illegal, in a way that they could not do for Acts of Parliament. Remember, judges must apply Acts of Parliament, but they can throw out delegated legislation where the maker has exceeded his powers. There's also an element of control under the Human Rights Act. We'll do that when we look at human rights. So that covers this topic then, sources of law.